Yeah, businesses who need that particular documentation. So yes, we'll just jump right into it. We have limited time. Just a few housekeeping rules. You can turn off your camera. If you have any questions that you want to ask, you can ask in chat box. And yes, we would entertain questions at the Q&A session. So yes, attendees of this particular webinar has or allowed or are given free complimentary consultation to talk about your business issues. If you have any legal problem, you want to speak to a lawyer, we are available. Just, you could either go to our Linktree account on Instagram or our website to book a session, or we'll reach out to you if you drop a notification at the chat or on the chat box, please. So yes, my name is Bernice Asen. I'm the founder and lead counsel at Cardinal Counsel. We are a business-oriented law firm committed to innovation and reimagining of legal service delivery by providing legal solutions to business startups and the creative industry. Yeah. Sorry, I just. Okay, so yes, introduction to the topic. Welcome to our webinar titled Startup Essential. Basically, we are excited, like I mentioned before, to talk about this because major aspect of the startup journey, really. You would need to, especially when you're working with other people or you have people coming on your team, you would need to have legal documentation because it's actually very vital to the sustainability of your startup venture. So in this today's we'll be discussing about the importance of legal documentation, the essential components, different drafting consideration. We'll talk about shareholders agreement and co-founders agreement, definitely, and also the common pitfalls that we actually see. Yes, so yes, we'll be talking about understanding the importance of shareholders agreement. We'll be talking about essential components of the co-founders and shareholders agreement. We'll talk about key provisions, rights, obligations, and different other things to secure and safeguard your interest of all the parties involved in that transaction. Would also be looking at drafting consideration. So the things that you have to consider when customizing a particular contract to your business model, basically, would also address the pitfalls and avoid, pitfalls to avoid, and also the best practice of drafting different agreements. So there are things that you have to consider before you draft this agreement. So yes, by the end of this webinar, you will have a deeper understanding on the importance of co-founders agreement, shareholders agreement, and as well as strategies that you will use to craft agreements for your business, basically. So let's delve into the agreement. Yeah, so one of the importance of co-founders agreement and shareholders agreement is because it lays a solid foundation for your business, basically, right? It's one of the fundamental elements that you actually need because you are going to be establishing rights, responsibilities for founders, shareholders, and every person that has an interest in that particular business, right? And to also help in protection of this interest, protection of the assets, and also dispute resolution. Because when two or more people are actually gathered, there is, bound to be all of those things. So how do we rectify this problem before it even happens? Agreements, I like to also say that agreements and contracts are a way to predict the future. So you may not know what will happen in the future, but you can speculate to contracts in case of things happening. What exactly are we going to do and how we're going to act? That's what the contract actually seeks to address. Yes, so what's a co-founders agreement? A co-founders agreement is a legally binding document that outlines the rights, responsibilities of individuals who establish a startup together. It serves as a foundational framework for collaboration. It helps with corporate governance. It helps with decision making throughout the life cycle of a particular startup, right? Yes, it serves the purpose, like I mentioned before. It serves the purpose of actually helping to sort out the issues that would eventually come up, issues as regards ownership stake. One of the major issues that you address with the co-founders agreement is deciding who gets what based on their contribution, based on what they bring to the table, their financial capacity, the time that they dedicate to the business. So it's very important that you have this in place, because addressing it would require that you have an agreement that stipulates all those things, right? Decision making authority, who has that? How do we resolve disputes when it happens? Discuss all of those things and address those things in your co-founders agreement. So the primary purpose of your co-founders agreement is actually to establish clarity, to help you have that conversation and mutual understanding among co-founders, and yes, how you can actually build a successful startup. So very importantly is the key elements of and components of a co-founders agreement, and one of which is equity contribution, roles and responsibility, and decision making. I will skip for now. I'll skip the equity contribution because we would go back to it, because it's one of the most important aspects of your co-founders agreement. So the co-founders agreement helps with defining roles and responsibilities and contribution to a particular startup. Usually, sometimes startups do not really have the funding to, pay staff, right? People come together with their skill sets and their ideas to build a particular business, right? So you have to determine what everybody is bringing to the table, because this would eventually also determine their ownership stake. So what exactly is each responsibility? So is somebody heading our marketing team? Is somebody heading the technical aspect of things? That's a CTO, right? Is somebody heading the operations? That's like the CEO or the CEO, whichever person that is like involved. Who exactly will be making sort decision and giving strategic direction to the team? It's very important that we have that particular element sorted out in the co-founders agreement. Also, decision-making process, we have to decide who makes critical decision that concerns the business, who would resolve those conflicts, right? And if people's rights comes with a voting on significant matters that affect the direction and the future of the business. Say, for instance, we want to rent an office space, right? How exactly are we going to reach that particular decision, right? Do we have the CEO make, absolute decision, or he has to consult the board of directors and all the key stakeholders? How exactly is that decision process made? So we have to stipulate these things in our co-founders agreement, so to speak. Another very important, if not the most important part of the co-founder agreement is equity distribution. Equity distribution specifies the ownership stake and equity percentage allocated to each co-founders, right? If you're the only person in your startup, you will probably not need that, because you might be allocating a 100% stake. However, when you have other people involved, right, you have to outline what equity they have and how it will be distributed over time. One of the things we'll also address is the vesting schedule. How will that particular equity become somebody's own? So for instance, I have 10% in my company, right, at the beginning, because we do not have money to employ somebody who is a lawyer. So I'm allocated 10%. However, how does that particular equity distribution comes into play? How does it become mine? How do I become the sole owner of that? How do I enjoy the rights of that particular equity? Everything that it bestows upon is, the vesting schedule, which states how that actually becomes mine totally. So yes, equity distribution helps to refer to the allocation of ownership stake and shares amongst, so I have 10%, my team has other 10%, other people has 10%, depending on what it is. And equity distribution is determined by different factors, right? The initial capital investment. So somebody might be investing money and equity money upfront, for us, while other people are not doing that. Somebody else is building the technical or the back end technical aspect of the startup, right? Maybe they're bringing their intellectual property and their expertise. That also helps in determining what equity distribution you would give to that person. It might be valued in terms of the prevailing market forces, but like, what exactly is the person really bringing, and how can we, value that in terms of, the entire value of our startup? So what's the time and commitment? Some people might not necessarily have cash, would not have intellectual property, but they are dedicated to the operations of the business and making sure that business attains success. So their time commitment and dedication. Sometimes some people would abandon their, 9 to 5 and focus solely on the business. So their time commitment and dedication, also future performance and milestones. For instance, somebody is saying that I'm going to bring in XYZ, or I know these angel investors that will invest XYZ. So what are the milestones that the person is going to achieve? They will also determine, what the person's stake really is. Yes, vesting schedule is also very important because it's an offshoot of the equity distribution. So once we have said somebody or XYZ is entitled to 10%, right? How exactly are we going to now vest, or how would that particular equity become theirs? What's the procedure, right? So the vesting schedule helps to outline the timeline and condition under which co-founders equity becomes theirs fully, or is owned outright. So how exactly are we going to put it in a way that it incentivizes our co-founder? So if I'm giving 10%, right? So 10% doesn't automatically become mine. It starts, becoming mine when I've fulfilled certain obligations towards the company goals, right? So 1% today, 1% tomorrow. The step-by-step vesting of that particular shares is what they call, the vesting schedule. What's the condition that I have to fulfill to actually own that? So there are many features of the vesting schedule, right? There's the vesting period, there's a cliff period, there is the accelerated vesting, and there is like for future provision. So basically, right, the vesting period is the period where that particular equity becomes yours, the process, the timeline that we have, right? But the cliff period is a period before the vesting starts. So maybe we are still trying to get our business registered, our IP off the ground, registered. We're trying to do, due diligence. We're trying to draft contracts, put everybody together. During that period, people are not necessarily investing directly. So we're saying that, we're going to have like an initial period of 6 months. So 6 months to get our acts together and decide what exactly is the features of our MVP. What are we building? And then, after we do that, basically, we can decide that, okay, after 6 months of discovering the major features we're building, talking to our, developers and all those things, right? Then we'll now start the vesting period. So yes, accelerated vesting is also, let's say, so you do something that will make you automatically own your equity outrightly. So I built the app. Once I complete the app, I have my 10% in full, right? So yes, that's also that. And also for future provision is where, people have invested with a particular share and they want to leave. How do they forfeit the equity that has been given to them? So yes, your vesting schedule is very important in your co-founders agreement. Then intellectual property rights is also added. Why this is important is because according to the copyright law, the intellectual property law, there's a basic principle that when somebody creates a particular IP, right, it belongs to them. So you will need your co-founders to assign that particular right to the company, either in a futuristic manner or immediately if your business is already registered. So, or post incorporation, so to speak. So it's very important that you make sure that every co-founder assign their rights to the company, assuming that it is registered. And if it is not, then they will have to do it on registration of the company. So it's very important that you have the intellectual property rights cleared. Who has it? How we're going to use it? Who has license to use it? And all of all those many things that you have to address into it. So there's also the capital contribution and funding, right? So how many and how much are we going to actually build and contribute to, the business? What exactly is our financial commitment? Are we going to be contributing quarterly? Am I going to, after we contributed an initial amount or initial capital, do we have to come back when the capital is actually exhausted to raise or to recoup capital from the existing co-founders? What exactly? So that particular session or element is very important in the co-founders agreement. So yes, why is it essential? Is because it helps with the protection of business. It helps with governance and decision making, like I mentioned before. It also helps with legal compliance and enforcement. It also helps with risk mitigation, when there's an agreement or where there is like an agreement as to collaboration or strategic decisions, people, have to, resort back to what they have initially agreed, right? Also helps with conflict, resolving conflict, right? It also helps with responsibilities and rights allocations, very important for startups. Yes, because we're behind time, I would run through it right now. So in summary, the co-founders agreement is a cornerstone document that helps startup with governance and a critical tool for fostering trust, collaboration, and accountability amongst co-founders, right? And it also helps with your entrepreneurial journey. You are sure that certain things are really secured before you put your investment and your time, your energy, and your finances into a particular product. So yes, the importance of shareholders agreement, right? Shareholders agreement is a vital document that helps with a company that has multiple shareholders, right? And there are several key benefits like offering stability, governance, and long-term success, right? So I would use, for instance, a recent incident that we had with how about Midway, for instance, where after his demise, a particular CEO or like head of the company was appointed. That's because there has already been an effective shareholders agreement in place where once one person dies, there is a reconvergence of the board of directors or shareholders to appoint somebody else so that the business doesn't die, but pick up from where the person actually stopped. That is to show effective proper shareholders management and yes, agreement, so to speak. So they are looking at the future of the business. So yes, it's very important that you have this in place because it helps with shareholder management or shareholders management. So the difference between co-founders agreement, why co-founders agreement focuses on the relationship and roles between startup founders, a shareholders agreement extends towards the shareholders. Shareholders are people who come together to fund a particular business. They come to take a stake in it. They are investors. So they are people who have interest. So you might be a co-founder without any, equity holding. You can also be a co-founder with equity holding. You can be a director with no equity holding. You can be a director with equity holding. So it depends, right? Some people are co-founders based on strategic guidelines and like what they bring to the table. It doesn't mean that maybe they are paid outrightly. It doesn't mean that they are shareholder. So you can actually be a shareholder without necessarily having management, rights, right? So it's very important that you understand what the shareholders are about. The shareholders will not necessarily talk about general roles and responsibility of each founders, but it would go as far as, provide for corporate governance and management of, the entire company. It serves as a check to what the founders really do in the company, so to speak. So yes, it also helps with rights and expectation of shareholders and how they manage their stake. Yes, so it also helps with protection of rights of the shareholders because nobody wants to invest in a business where their rights and interests are not safeguarded by any documentation whatsoever. It stipulates their roles, responsibility, and entitlement within the company. It also talked about how dividends are shared amongst shareholders. It helps with accountability and transparency. It also helps in resolving dispute. One of the major roles of contracts, of course, is to resolve disputes. Key elements of shareholders agreement, we have share ownership and transfer restriction. So what is the shareholder and their interest and how they can transfer this to one place or another because it's an asset, right? So how do they move it, right? That's what your shareholders agreement will be addressing. So the rights and obligation of each shareholders will also be stated there. There's also the management and control of the company. It establishes governance, structure, and mechanism for managing the affairs of the company, appointments of directors, composition of board committees, and delegation of executive authorities. Also helps to define decision-making process and voting thresholds of companies. It also helps with exit and buyouts. One of the ultimate things of a lot of startups is that they are bought or they are exited, and shareholders can make their money. So it stipulates how this is really done, the buyback, stag along rights, drag along rights, and all the options that is available for shareholders to actually use. So yes, it's very important that we have that. So by addressing these key concerns in your agreement, you can now have a robust framework for corporate governance, shareholders relations, and strategic planning and transparency of the board. So when you're drafting, it's very important that you consider so many factors. First, you have to be sure that the agreement is tailored to your specific needs. So don't just go download documents. Be sure that that document recognizes your unique features and your circumstances and your goals, right? And customize document to meet the needs and objectives of a particular business. Another thing is also be transparent with your team. Have conversations about what you want to, achieve. Be very clear as to, the terms and conditions that you have in place. Be transparent with your team. That it's easy for everyone to understand. Also, seek legal advice, seek professional advice when you are drafting a contract. Seek professionals. Let them talk to you about the nuances of a shareholders agreement and how they can tailor it to your unique set of circumstances, right? It's very important that you have that. A well-drafted contract can help you establish a solid foundation for long-term success and mitigate risks for your business, so to speak. So common pitfall, do not avoid reviewing this regularly, address key issues, have conversation, be clear with your co-founders as to what you want so that you can address mutual concerns and other promote collaboration, so to speak. Don't assume, make sure you have the conversation so that trust is not broken down and solution is actually met or misaligned, so that it's also not misaligned, so to speak. So yes, we've come, down to talking about the importance of those basic contracts, and how that you can use it. So at the key takeaways that we have is that you need contracts for clarity and transparency. You have to customize those contracts to meet your unique and specific goals. You also have to work with a lawyer, seek professional advice in drafting comprehensive and enforceable agreement. You also need, regular review of those contracts if you have it to because business is changing. So, right, you need to actually address those issues and regularly review your documents, right? Then yes, it is very important that co-founders agreement, this agreement form legal foundations, and you can't do without them. You have to have them, especially when you're not the only one in your startup, right? Yes, I will jump to the question and answer session. And if you don't have any questions or whatever, you can send us a private message and we'll be willing to answer you. Also, people who participate in this particular event actually have direct 30 minutes free consultation with our lawyers to consult on unique challenges that they are facing. So yes, you need specialist advice, as we said before. We provide that at Cardinal Counsel. We are a law firm for startups. We can help you with your business structuring, drafting bespoke contracts, and reviewing bank contracts and commercial relationships, so to speak. Just help us. We help businesses navigate all the legal requirements that they have to actually build a solid foundation. So you can contact us at www.cardinalcounsel.com. And we'll be willing and happy to receive your information. We'll see you on our next March webinar. We're talking about other issues that pertain to startups and businesses with entrepreneurs across fintech, edtech, and across different sectors, so to speak. And we'll be communicating, of course, the registration requirements for that particular webinar. If that is all, I want to say thank you for participating in our webinar. We do this often to share knowledge with our community and be sure that people have clarity as to how to navigate legal issues with their startups. My name is Bernice Asen, and Cardinal Counsel is here to help you. We'll see you on our next event coming up, the last Friday in March. Thank you. Yeah. I would be exiting the meeting now. I don't think that this particular part is important.
All right.